Well, good morning, ladies and gentlemen. It's an enormous pleasure for me to be here. As was said earlier, this is my first ever visit to Oman, and I'm very much looking forward to the next couple of days. Many thanks to the Centre, His Excellency, the Chairman, for the invitation to be here. And can I just say before we go any further, thank you also to the staff of the Centre who have been immensely helpful to me in setting up my travel arrangements, getting me here, accommodation, and so on. So this is a very interesting and exciting event for me to attend. When I think back on my career, I realised that I first started to study competition law 42 years ago, and I have to say that the world in 1977, when I started to study it, and the world today is immensely different. In 1977, there were very few systems of competition law in the world. There were really only 5 or 6 that had any kind of significance. But here we are today in 2019, and there are at least 130, possibly by now 140 systems of competition law. And one of the things I have found most interesting throughout my career has been to go to jurisdictions where competition law has been newly introduced. Because I think that when a country introduces a law like this, it's exciting, it's important, but it's also very difficult. And a lot of people have to learn a lot of things very quickly. Obviously, one has to equip a competition authority and to invest in it and recruit the right staff. And you also have to then educate the business community on the one hand and the civic society, the consumers themselves on the other hand. And it is quite a long and complicated process. As was mentioned earlier, I was in Mauritius last week where they were celebrating the 10th anniversary of competition law. But as Russell was suggesting in his presentation before me, when you look at what the Mauritians have done in 10 years in the application of their competition law, they have achieved some very significant victories. And when we had the questions before coffee, it was interesting. People were discussing the international context of competition law. And of course, there are lots of cartels that by their nature are supranational. Air cargo, almost by definition, is an international, supranational cartel. And so sometimes people think, what is there left for a local competition authority to do? But of course, at a local level, it's perfectly possible to have cartels between hotels or at the level of retail and insurance, retail banking and insurance, or taxi drivers, or you sometimes come across cartels in bread and candles and the most basic commodities sometimes that crucially are important to citizens. So there is a role for the big authority tackling the big international problems, but for the local authority tackling problems that are specific to its own circumstances. So I'm a great believer in individual countries having their own competition laws. Now, I've been asked to speak about 2 different things. The first is competition law and policy in the digital economy, and that's what I'm going to tackle first. And what I'm going to do is to talk for about 40 minutes, not more, because I really would like to give you, the audience, the opportunity to make comments and ask questions. So I will stop at an appropriate point for that to happen. And then I've also been asked to talk about something which to my mind is entirely unrelated, which is predatory pricing and dumping. It's a very, very different topic. I tried to think of clever ways in which I could integrate the digital economy with predation and dumping, but it was absolutely beyond me. So what I've done in fact, is to create two different PowerPoints. So I will stop at a suitable juncture and take questions from you for 10 minutes or so, and then I will move on to predation and dumping. And can I just ask, is my session due to end at 12:30 or 12:45, just so that I'm clear? 12:30. Okay, thank you very much. Good. Okay, so I have lots of slides. I think there are 28 slides on the digital economy, and I cannot possibly deal with all these slides in the time available to me. But as I was thinking about the topic and becoming more and more absorbed in it, I kept producing more slides, and then I thought, well, hopefully people who want to take this to the next level, they can have the whole slide deck available to them to look at afterwards, but I won't be able to address each and every one of these slides. I'm told by the organisers that these PowerPoints can be made available to you in a soft version. So if you do want to gain access to these slides, get in touch with the centre. So in the slides on the digital economy, I've got a few general introductory points to make about the role of antitrust and its significance, firstly historically, but also now today in the digital era. I've got a few slides specifically on antitrust policy in digital markets. Inevitably, the debate becomes one about the platforms, GAFA, Google, Amazon, Facebook, Apple, etc. And so I've got a few slides where I address the question, why is it that politicians, governments, regulators feel uneasy about the platforms nowadays? What are the problems? And if there are problems, what tools can countries use to address those problems? But then I need to drill down specifically into competition law. A question is, what can competition law, as opposed to other tools, give to the debate? There are some more slides after that. Frankly, I doubt whether I'll have time to go into them. I will at least show you what's there. So, just by way of introduction, I do think it's very interesting that nowadays, when one is looking at the debate about economic policy generally, where are we? What's going on in the world? What's new? And I find that one can be looking in the media, listening to what stakeholders have got to say, and one regularly finds governments, ministers, authorities, politicians saying, what are the competition authorities doing about these platforms? And I mean, over there in my binder, I've got editorials from The Economist, for example, or from the Financial Times, editorials saying competition authorities aren't doing enough. When are they going to take on these digital giants that are getting bigger and bigger and bigger? And I have found that interesting. Even within the last year, I've got snippets there where these kind of publications are addressing that question. And The Economist and the Financial Times, for example, they are absolute believers in the free market. They absolutely want to see government off the backs of firms. They don't want to see oppressive regulation. They don't want competition authorities messing up legitimate business behaviours. And yet at the same time, those very publications are saying, but what about the digital giants? So there's a sense in which competition policy today, in 2019, seems to me to have a kind of a prominence that it hasn't had for more than a century. If you go back to the United States at the end of the 19th century and the start of the 20th century, when there were great economic problems there, one of the problems absolutely was about the monopoly power. Firstly, that railroads had. Secondly, that the oil companies had. The problem actually was monopoly. And this led to the Sherman Act of 1890, which was found not really to be powerful enough. So that led on to the Clayton Act and the Federal Trade Commission Act of 1914. And this was actually about giving the state the power to break up monopolies. And various actions were then taken. You then get 100 plus years in which competition policy has been used at different times to achieve all sorts of different outcomes. And I won't even begin to go into that. But monopoly itself as the problem sort of receded into the background. Sometimes it was more about achieving fairness or protecting little businesses from big businesses, but not monopoly as such. And then, in recent times, we get the digital era. And we see before our very eyes Google, Amazon, Facebook just apparently getting bigger and bigger inexorably, and then stretching out their tentacles into ever more markets and apparently ending up with a power that appears almost to seem unaccountable. And so you see this gigantic cycle where the concern of monopoly 130 years ago becomes a concern again today in 2019. And so in academic literature, you get people like Lena Khan publishing an immensely powerful article in the Yale Law Journal a couple of years ago, in which she basically says, my God, Amazon, what's going on? Who's going to do something about it? And she called her article Amazon's Antitrust Paradox, distinguishing herself from Robert Bork's book, The Antitrust Paradox from the 1960s, 70s, where he said the problem is competition law is stifling business. And then she says, what a paradox is that? And then she says, yes, but Amazon is a very successful company, but it is stifling competition. So it was a very important moment in history when she published that. And then it was followed by Tim Wu's book on the curse of bigness, where he kind of questioned precisely that, the bigness, the size of some of these platforms. Beg your pardon, I went on one too many. And we heard from Russell earlier about, well, what's the standard that competition authorities apply? Predominantly, it's consumer welfare. And when we say competition authorities are concerned with consumer welfare, one version of that is to say, really the question is, this firm or these firms, when they behave in the way that they do on the market, or if their merger is allowed to go ahead, will it lead to higher prices? And that somehow consumer welfare means low prices for consumers, and conduct that will lead to higher prices equals bad for consumers, then competition law has a role to play. But then people, especially in the digital era, have started to say, well, is that really good enough? Is it really just about this narrow formulation of consumer welfare and price? And then a few years ago, various commentators started saying, this obsession with consumer welfare in the sense of price, it's too technical, it's too limited, it's rather sterile. And a problem with it is that it means that if competition authorities are applying that standard, they're missing out on all sorts of other things that are important. And Russell was talking about these kind of things. If you just say, leave it to the market and price, does that not mean sometimes that you get obvious unfairness in markets? And should competition authorities be concerned with unfairness? And there's there's consumer welfare as a kind of a technical tool of economics. And consumer welfare is about what happens to customers, and the customers paying higher prices. But then, who are these customers? And you've got different customers. You've got customers who can look after themselves and make rational, sensible decisions and exercise choice. But you have lots of other customers, consumers, who we can call disempowered, who don't make rational choices, who perhaps don't have the education to exercise choices that are theoretically available to them, but they don't actually exercise. Or maybe they just don't have access to sensible information, or, numerous things one can say about that. But is the consumer welfare standard sufficiently responsive to different categories of consumer, especially to the needs of disempowered consumers? Another issue is, you've got these markets, and lots of firms are doing very well in those markets, and they're making lots of money, but who gets the benefit? Who gets the profit from what these companies are doing? Is it all going to shareholders and pension funds and hedge funds? What about the workers? What about the employees? Are they getting a fair share of these wonderful profits that are being earned? So should competition policy concern itself with the needs of employees? And then what about distributive justice, that somehow the world seems to be ever characterized by greater inequality? And should competition authorities be concerned about that? Now, people that were discussing these issues over recent years, let's say from 2016, 2017, they were often regarded in respectable competition policy circles as rather eccentric, the kind of people that couldn't do anything in the world, and so they became academics, the nutty professors in the universities who get paid for writing obscure articles using language that most ordinary people wouldn't understand, because that's what academics tend to like to do. And so this came to be referred to as hipster economics, kind of people that are divorced from the real world and should really be put on an island together and left to debate these fascinating issues. But then along came the digital economy, and many of these things actually seem to unfold between our very eyes. That there was massive power, ever concentrated in fewer digital giants, and somehow the fruits weren't being adequately shared, and that maybe competition policy needed to be rethought in some sense. And so that slightly pejorative label, hipster economics or hipster antitrust, has kind of receded into the background in recent times, and these kind of issues have become much more part of mainstream discussion. And it is because of the platforms, Google, Amazon, Facebook, Apple. Of course, there are others. And when we look at platforms of this nature, we discover that they have certain characteristics that seem to suggest particularly close attention is required. In particular, platform markets are very often two-sided or multi-sided. So I use Google, so there's one side of the market, but advertisers advertise on Google. And advertisers will advertise more depending on how many consumers use Google. And then the two sides of the market reinforce one another. And the more users use Google, the more advertisers advertise on Google, and the more advertisements there are, the more information there is, the better it is for us as consumers. So you have a two-sided or sometimes a multi-sided market. That is a characteristic of platform markets. There are enormous economies of scale and economies of scope to be achieved. Specifically, you have network effects where more and more people join the same network, and that reinforces everything that I've just described. And then when you have this network effect, the possibility exists that a particular market, in the end, tips in favour of one firm because everybody uses Google and nobody uses anything else. Somebody the other day told me that he had used Yahoo the other day to find Google. Interesting idea. There's also an issue then around big data in particular, and I'll come back to that. So the debate has changed because of digital markets. And then coming back to my consumer welfare point, one version of the consumer welfare standard is that it's all about price. But then the trouble is, if you look at me, Richard Whish, using Google, what price do I pay for using Google? Answer, it is free. So how can we talk about a version of competition law or policy which is all about price when to me, the consumer, Google is free? And of course, Google is amazing. One thing I have learned today, which I didn't know, is that Qatar are playing Oman on Tuesday evening. Thank you, Russell, for that information. So as he spoke, and I apologize if this was rude, I immediately went onto my mobile phone in the hope that this game was being played in Oman, because then I was going to say, can we go and see it, please, tomorrow evening? But I discover actually it's in Qatar, so that was disappointing. But my point is that in front of me, on the table there, was this incredible device, free to me, that enabled me to find out about that football match. So it is remarkable. But then how does this consumer welfare / price theorem apply when something is free? I won't go into it, but if you get into competition policy cases, you have to define the relevant market in which somebody is allegedly dominant or in which competition is being harmed. And some of you will know, I'm sure, that competition authorities tend to use the snip test to define a market, whereby you say, here am I producing apples. If I were to raise the price of apples by 10%, would consumers switch to oranges instead? And depending on the answer to that question, you define the market, which may be limited to apples, but may be as wide as apples and oranges. But this is done through the prism of pricing behavior. Well, how do you apply the snip test to me using Google free? Because if you raise the price of 0 by 10%, I was never a brilliant mathematician, but I'm sure if you raise the price of 0 by 10%, it will come out as 0. So it doesn't seem that the snip test has much application in a world of free services. Now, of course, there are answers to that, but I'm just saying there are fresh challenges in this digital era. And so the question is, therefore, do we need to rip up competition law and start all over again? Or, on the other hand, do we all have intelligently to understand digital markets and to calmly work out what can competition law achieve, while at the same time accepting what competition law cannot achieve? So, should we rip everything up and start again? No. My final slide there. What we do have to do is to say to ourselves, well, what are the problems with platforms? Are there problems with platforms? And of course we have got to accept that platforms have achieved incredible outcomes. And all of us, our lives are enriched by the services that are now available to us. And so, to put it in simplistic terms, should one see platforms as being like the railroads and the oil companies 120 years ago, or should one say, just leave it all to the market? because markets, in the end, always correct themselves. And you can have what appears to be great monopoly power, but if you leave it to the forces of competition, even the monopolist will eventually be destroyed because somebody new will enter the market. Joseph Schumpeter, a Nobel Peace Prize winning economist, talked about the perennial gale of creative destruction. So somebody becomes a monopolist, but in due course, that monopoly is blown away by something else that comes along. And it is interesting when you think of digital markets. I remember going back 40 years when the big competition cases in the world were authorities taking on IBM because of their dominance over mainframe computers and the operating systems that ran the computers. And they were tying and bundling and monopolizing, and something had to be done about it. And what happened? A man called Bill Gates came along, and he saw the future, and he said, the future's not going to be about mainframe computers. It's going to be about laptop computers and or standalone desktop computers. I'm going to devise a new operating system for that. And what happened? IBM, what happened to them? They had to go away and completely recreate themselves as something else. So there was Microsoft in its incredible powerful position at the end of the 20th century, beginning of the 21st, and what happened next? Google. And Google somehow took over from Microsoft. There's Google there today. Who will it be in 10 years from now? So the extreme views are get in, break them up, it's all bad. And the other view is don't worry, leave it to the market. In due course, it will auto-correct. And what is interesting, I find, with digital markets is we in Europe more skeptical of markets, I think, it would be fair to say. The Americans, as a general proposition, much more hands-off. And for much of the 21st century, there didn't seem to be a great appetite in the States, the Federal Trade Commission and the Department of Justice, for taking on the platforms. But something changed about 2-3 years ago, and even in the States, politicians and the FTC and the DOJ started to say, hang on a minute, there's something going on here. And I think when the history books come to be written, people might look back at the Facebook Cambridge Analytica scandal of about 2 years ago, when individuals' data, it seemed, were being aggregated and made available to the Republican Party as part of the campaign to get President Trump elected, and we, the consumers, had no idea that our data could be used in this way. And it alerted politicians, governments, regulators, and, importantly, us as individuals, to the fact that these things were capable of doing things that actually we didn't necessarily have very much knowledge about. And so I think that the agenda has changed. And there's been a series of reports in recent years, the Stigler Institute in the States, the Furman Report in the UK, the Kramer Report in the EU, a concordat now between the FTC and the Department of Justice. Who's going to deal with the GA of GAFA and who's going to deal with the FA of GAFA? We've entered a different world. And these issues are now much more closely scrutinized than they were even a couple of years ago. Now, I said earlier, what we've got to do is to be calm and be intelligent and ask ourselves, if there are issues around these platforms, what are the issues? Because we're here as the competition policy community. So what can competition policy do? And what issues are best left to other authorities and other tools? And if you think of the litany of complaints about platforms, some of it is to do with fake news. And I'm sure there are issues about fake news. Doesn't feel like a competition law issue. Political manipulation. Was the election of Trump partly achieved through what happens online? Maybe. Is it possible for me to incite violence? Is it possible for me to encourage terrorism online? Well, yes, frankly, it is. And then, therefore, what obligation should be imposed on Facebook, for example, to ensure that funds aren't being raised by terrorists online? Interesting one, data privacy. You probably do know that the Bundeskartellamt in Germany, the German competition authority, has used competition law to achieve greater standards of data privacy for German users of Facebook. That's an interesting one. Is that really an issue of competition law and policy, or is that really an issue of data protection? Somebody might want to ask me a question about that in due course. Query, these platforms, they deal with other businesses, and they deal with us as users. So that means there are millions of contracts between the platforms, commercial businesses, us as users. Well, it may well be that some of the terms and conditions of those contracts are unfair, unequal, unbalanced. Is that a competition law question, or is that a question to be addressed through specific legal instruments such as laws on unfair trading terms, unfair commercial practices? So lots of issues there. Query, where does competition law come in? And I always think it's useful when you identify problems to ask the question. You can look at the whole set, the whole portfolio of legal powers available to authorities in Oman or the United Kingdom or the EU. What legal tools are there? And then, of those legal tools, which is the right one to address which problem? And of course, there will be laws on media regulation, on electioneering and what can and cannot be done in an election. Of course, there are criminal laws about inciting violence and funding terrorism. There is, or may be, legislation on data privacy. We in the EU now have a very powerful regulation on data privacy protection, and there are laws on unfair commercial practices and unfair contract terms. So there are lots of tools available. But of course, there's also competition law. And this is where it becomes interesting. So what is it that competition law can achieve? Now, competition law is relatively new in Oman. The next 5-10 years are going to be immensely interesting as the authority gets fully up and running with its regulations and so on and so forth. And lots of challenges lie ahead for the authority, but also for the lawyers and the business advisors, and of course for the businesses themselves. I don't know whether people yet are familiar here with the vocabulary of the competition theory of harm. If a competition authority is going to use its powers, its competition law powers, the powers in Chapter 2 of your Act, why is the authority going to use those powers? It must be because it thinks that a firm or firms are doing something wrong. In other words, it must have a theory of competition harm. And in formulating a case, whether you're on the public side enforcing law, or whether you're on the advisory side advising clients, you have to try to think through what might the theory of harm be in this case. So at its simplest, why do competition laws deal with price fixing so severely, what's the theory of harm? Well, that's the simplest one of all, that basically horizontal price fixing between competitors is likely to lead to higher prices. So there's a nice, simple theory of harm. Alternatively, if you have a dominant firm, a domco, with very few competitors, there are people trying to enter the market, but the domco has gone to all its main customers and said, we will supply you with widgets, but on condition that for a period of 10 years, you do not buy widgets from anybody else. Well, I can see a theory of harm here. How can somebody possibly get into that market if all the important customers have been tied up through exclusive agreements? So those are kind of simple, straightforward cases. So what I've then done here is to set out in a few slides some theories of harm that have been or are being used in digital markets. And I've just got 3 slides on these theories of harm. I will present them briefly, and then I'm going to stop this presentation and go over to you for questions. But this is real-life application of competition law in digital markets around the world, more specifically actually in the EU right now. Data, big data. One of the things that Amazon and Facebook and Google can do is, because millions of us use these apps, Google, Apple, Facebook accumulate vast amounts of data about us, about where we search, possibly about our friends with whom we communicate through Facebook, WhatsApp, etc. Vast data come into the possession of one firm, maybe many firms, but maybe one firm in particular. Query: is it possible that a firm ends up with so much data that it is impossible for anybody else, or extremely difficult for other players, to occupy that firm's market because of the advantage that data confers? To turn that around, therefore, in competition law terms, if I am Domco, the dominant firm, sitting on vast amounts of of data, might my refusal to share that data with a competitor prevent that person from successfully competing in the market? Could a refusal to give access to data ever be an abuse of a monopoly or dominant position? We have cases on that in Europe. It goes back to a case many years ago, not about digital markets, called McGill or TV listings, but that has subsequently been applied to digital issues, starting with the Microsoft judgment in 2007. A refusal to grant access to data in that case was an abuse of a dominant position, and the European Commission is doing a case right now on Irish car motor insurance, when a trade association in Ireland, Insurance Ireland, is sitting on a vast amount of pooled data from insurance companies about the claims history of Irish motorists. Third parties want access to the Irish market, but they claim that the data are being withheld from them so that the incumbents have an advantage that it is impossible for would-be entrants to replicate. So that's the case active right now in Brussels. Then we find in platform markets that there's a frequent use of so-called parity, price parity, and non-price parity terms in agreements. Historically, these have often been called most favoured nation clauses. I don't think it's a useful expression. That's from trade law. Let's call them parity clauses. So I am Expedia or Booking.com. I allow major international hotel groups to advertise using my platform, but I, Expedia, say to the international hotel group, IHG, if you want to advertise your hotels on my platform, you cannot offer lower prices for your rooms on other platforms. Query, is that justifiable? Is that illegitimate? Query, is that preventing other platforms who might have better business models from successfully competing with me? There's been lots of cases on that in Europe. It's an ongoing debate. We'll see where it ends up. For the most part, those clauses have been prohibited. There's a case at the moment, Amadeus and Sabre, online booking systems for aviation markets, precisely the same thing. In the UK, we have precisely the same thing. Compare the Market, a digital comparison tool for purchasing home insurance products. Compare the Market using price and non-price parity clauses. So, lots of that. Another very interesting case at the moment the Commission is doing is Amazon. Amazon maintains the Amazon marketplace. Distributors can sell their products through Amazon. Amazon, at the same time, is a retailer of products, including retailing the products that other distributors are selling on the Amazon marketplace. And then the contracts between Amazon and those distributors enable Amazon to mine the data of what those distributors are doing and use the data for their own commercial purposes. Well, of course, if they know that distributor X is selling at a particular price and is focusing on particular customers in a particular part of Europe and being very successful, then query, can Amazon use that data in order to ultimately annex that market and push the distributor out? So that's an ongoing case. And then we've got 3 Google cases in the last 2 years in which the Commission has now imposed fines totaling 8.2 billion euros. And in 2 of those cases, essentially the argument is that Google had dominance in one market and was using that dominance to take over some neighboring market. So it's a kind of a leveraging idea. I'm dominant in widgets, and I use my power in widgets to take over the Blodgett market. And so Google Shopping, I go online, I want to shop for something, I want to buy a new greenhouse for my garden, I Google greenhouses, I'm happy to buy this product online, and on page 1 of the search results, I discover Google Shopping, and Google Shopping is a place where I can buy the greenhouse. There are other shopping tools that might be better than Google Shopping, but they never come up on page 1 of the results. Actually, those shopping tools, the Commission analysed this and said normally the competing shopping tools appeared on page 4 of the search results. Then different research shows none of us, humanoids in this room, ever reach page 4 of a search, because basically we make do with what's on page 1. And so the theory there is that you've used your dominance over general search to annex the neighbouring market of shopping online. Android, similar theory there. And another different case, Google AdSense, selling intermediary services to publishers and using long-term exclusivity agreements. So those are theories of harm applied to digital markets. I'll just say that you might have a theory of harm, you might find an infringement of competition law, but that's not the end of the competition authority's problems, because it then has to say, well, if that's the problem, what's the remedy? And, I mean, this could be an hour's presentation in its own terms, and I'm not going to do it. But just to say, competition authorities sometimes find that the theory of harm and the finding of abuse is the easy bit. The difficult bit is knowing what to do about it. I mean, ask me questions about that if you like. I'm going to have to stop there because of time, but I just wanted to point out there's a totally different issue. Well, no, not a totally different issue. There's a related issue of so-called disruptive technology. Uber, Airbnb, these wonderful apps that we can make use of in this day and age, and these disruptive technologies can be immensely beneficial to consumers, but of course immensely disruptive to local businesses. And in Mauritius last week, the very thing I was asked to speak about at that conference was disruptive technology. So I have just included that set of slides in this presentation pack if you want to have a look at them, but I just cannot deal with them now. The last thing I wanted to mention is that in digital markets, there's this very interesting discussion about what are called killer acquisitions. And this is the anxiety that competition authorities have nowadays, that you can have, for example, a dominant platform, Google, whoever. Remember I talked about IBM being replaced by Microsoft, being replaced by Google. Query, is there a danger that Google today buys up startup digital companies, not simply because it looks like a good investment, a good purchase? Query, might the reason for the acquisition being to stop the very potential competition that Microsoft represented to IBM and that Google represented to Microsoft. And so there's a whole debate and literature around so-called killer acquisitions. For the sake of completeness, I wanted you to know that phenomenon exists, but that's the end of this bit of my presentation. So I'm very happy now to stop and take questions from anybody if there are any, and then, if not, I'll go on to predation and dumping.
Thank you, Richard. We'll start with His Highness.
Yeah. Avoiding hogging the mic here, but it's interesting with the theory of harm. For us in whatever jurisdiction, when you're trying to apply the law, there's a question, and I think in the last slide, or the last couple of slides, actual versus potential harm.
Yes.
And the Omani law obviously looks at not simply the monopoly existence or the market concentration, the high market concentration, but it actually focuses on this theory of harm. So my question would be, for authorities and regulators at various sectors, are we chasing the actual or are we chasing the potential?
Yes, very, very good question. What I would say to that is that it must be the case that competition authorities are thinking about the future and not simply curing things that happened in the past. In particular, if you're applying merger control, what is merger control about? It is about looking to the future, because at the moment you've got X and Y competing with one another, and then X and Y are proposing to merge. So in that situation, of course, you're asking yourself, in the future, will things be better or worse than they are at the moment? So competition authorities inevitably have to speculate about the future. More specifically, do they simply look at the market today and say, X and Y are competitors, so let's look at the state of competition between them, and ignore the fact that Z is out there with the capacity to enter the market? Because in that situation, obviously, Z is not an actual competitor, but it is a potential competitor. Well, I mean, to my mind, it would be ridiculous if the existence of Z were to be discounted entirely because it's not already in the market. The relevant question is, how easily could it enter the market? How plausible is it that it might enter the market? And if it is right now plausible as a competitor, then it must be taken into account. Some people will then say to me, well, how far into the future should you look? Is it 1 year? Is it 3 years? Is it 10 years? And I'm afraid the answer to that is, it always sounds like a cop-out when I say this, it depends on the facts of the case. But of course it does depend on the facts of the case, because there are some markets in which somebody could enter very easily. There are other markets, if it's building train sets capable of travelling at more than 400 kilometres per hour, well, there are very few people at the moment who do that, and it's going to take a very long time before anybody else can do it. So, of course, you have different answers to the time question depending on the product. I think, therefore, it actually comes in legal terms down to whatever rules of evidence you have in a particular legal system. We, applying competition law, for the most part, will ask the question, is this behaviour, is this merger harmful to competition on a balance of probabilities? Meaning, is it more likely than not that this merger will harm competition? And so I think to some extent it's through rules of evidence that you control how speculative or fanciful or over-imaginative a competition authority might be. But it does depend on the particular market. I said to somebody earlier, competition policy in practice is about the economic analysis of markets within a legal process. There's a very important role for lawyers to establish the rules, the system, the evidential regime, but then economists are the people who actually analyze the market and come up hopefully with intelligent assessments of how the market works and how the market will work in future. But you've got to have economists and lawyers working cooperatively together. There's a question over. There's one behind. This is a question from an economist, I believe.
The economist is going to play the devil's advocate here.
I thought you might. That's what economists do.
All right, so let's put it this way. We're trying to prevent harm. First question is, harming who?
Mm-hmm.
If we think about these platforms, their monopolistic power is actually constructed by economies of scale, network effects, big data, which in the most part are provided willingly by the final consumer. And these aspects make these platforms grow so big and enable them to provide the final service or product to the final consumer at the lowest price possible. So if you ask, make a survey, probably would come up with an answer like, people don't want Google to be broken down because maybe the service is going to be rising in cost. Instead of being $0, it's going to be $1. So who are we trying to protect here? Protecting the competitive environment. Competition should eventually lead to higher social welfare levels. Would breaking up all these big guys increase social welfare?
I get the drift of this, and I'll reply now simply because I'm worried about time. I totally take the point. that, and I had a slide specifically that acknowledged the fantastic benefits to consumers from the platforms. And it is undeniably an extraordinary thing that I have access to the amount of information that I have through my smartphone, and that the apps themselves know so much about me that they guide me to the very things that I'm looking for. So it's absolutely clear that consumers do benefit from free services. I think my response to that would be to say simply this, that but hold on a minute. Are these things actually free? They're free in the sense that I don't pay any money for use of the service. On the other hand, am I not paying with the amount of information about myself that I make available to the platforms? That is something that merits deeper investigation. It may well be that after an economic analysis within a legal process, you come to the conclusion there's no problem here. And if there's no competitive theory of harm, then okay, let's leave it at that. But there might be. I'm simply saying that there might be. Of course, it might be that the problem turns out to be not about competition, etc. The problem might be a problem of privacy. And if it's about privacy and what's being made, what use is being made of my data, then it's quite right that that should go to a data privacy commissioner and not to a competition authority. So it's a very good question, and I'm not dodging it in any way whatsoever. I would, however, say that it's not quite as simple as it's free. It's not free in quite the sense that that term is often used. Okay. I'm just thinking, should I perhaps go on to the next bit of the presentation, simply in the interest of time, because I was asked to also talk about the relationship between the law on predatory pricing and dumping. And from what I understand, this I suspect this has greater impact and daily significance here at the moment than the somewhat abstract things I've been talking about. And I know there are cases in Oman around this area. If I understand correctly from my Google searches, Oman has been accused of dumping, and Oman has accused other countries of dumping. So this is topical. I've never been asked to do a presentation on predatory pricing and dumping before. So this was a nice challenge, and I rather enjoyed the mental process of thinking this through. So I've got a few slides. What do we mean by predatory pricing and dumping? What does predatory pricing mean in competition law? What does dumping mean in trade law? And what are the differences between the two? And so to begin with, there are similarities, because a firm operating on the market in Oman or the UK or the United States might complain that a competitor is charging prices that are unfairly low. You know, we compete on price, unless we're in a cartel. We compete on price. Somebody comes in at a lower price, and we say, well, there must be something strange going on here. That's not fair. How are they able to charge that low price? And so typically the complainant, looking at these widgets coming onto the market, will complain to a competition authority, or maybe to some other regulatory authority, or maybe to a government, saying something's going on here, sort out these unfair prices. And the relevant authorities may be able to take action against predatory pricing, and they may be able to take action against dumping. Always worth asking the question, well, how is it that these companies are able to charge these unfair prices? Is it because they're getting unfair subsidies from somewhere? Is it that the government of Ruritania is giving them loads of money so that they can dump their goods in another country. So the subject is related to laws on subsidy, or what we would call in the EU state aid, but the specific phenomenon I'm talking about now is not how is this possible, but what is it? What is predatory pricing and what is dumping? So first of all, we've got competition law, and I've got several slides on predatory pricing as a concept in competition law. Competition laws, including your law, of course, has a law on agreements, it has a law on abuse, and it has a law on mergers. We have Articles 101 and 102 of the treaty and the merger regulation. You have Chapter 2 of your Act. Predatory pricing, if predatory pricing occurs, it will be dealt with under the abuse provision. This is going to be an accusation that a monopolist or a dominant firm has abused its position by offering predatory prices. Note that if DOMCO, if the dominant firm is charging predatory prices, then it will be committing an offence. And if it's committing an offence, then it means normally that it can be fined. And in many countries, if it's caused competitive harm to particular competitors, it can also be sued for damages. And that does happen in practice. So predatory pricing, it's part of competition law, it's committed by a dominant firm, and it is an infringement, and sanctions can be imposed. Predatory pricing as an offence is something that is committed by a monopolist or a dominant firm. So it follows that if a firm is not dominant, it can't be accused of predatory pricing. It might be giving away its widgets for zero, but it's not capable of infringing the law because it doesn't have a dominant position. What is a dominant position? Give me an hour and I'll take you through that. I don't have an hour. You have deemed dominance, where a firm has more than 35% of a market. We have presumed dominance, where somebody has 50% or more of a market. What exactly is predatory pricing? It means that DOMCO is selling at less than cost. So the idea is, how could a dominant firm stay in a market and incur losses? It doesn't make sense. So surely the point must be it is incurring losses because there's some wretched competitor trying to enter the market. So let's drop my prices, get rid of them, and once I've got rid of them, I can then put my prices back up. So the essence of predatory pricing is selling at a loss. And Article 10 of your Act says dominant firms mustn't abuse their dominance, and then 10A specifically gives an example, selling the product at a price lower than its actual cost. So explicit rule, predation below cost selling. Next question is, well, what is cost? Can I have another hour? What is cost? Is it average variable cost? Is it average total cost? Is it average avoidable cost? Is it long run average incremental cost? Is it marginal cost? Not the easiest thing in the world. When you do cases on this, you can sometimes lose the will to live because it becomes so unspeakably tedious. It's not true, but thank God for accountants. Don't often say that, but they can be very useful when it comes to this kind of thing. So that's predatory pricing. It's committed by a dominant firm. It's selling at less than cost, and it can be punished. And we've just had a case in Europe a couple of months ago. Qualcomm, Californian giant producer of chipsets, faced with a competitor in chipsets used in dongles, that are devices that can connect a laptop to the Wi-Fi system. ICERA complains that it's the victim of predatory pricing. Qualcomm found guilty in July of this year, fine of 242 million euros. Now on appeal to the General Court. It'll be very interesting to see what comes out of that. But of course, assuming that the decision is upheld, that was an infringement, clearly ICERA will then bring an action for damages for the losses they sustained as a result of being evicted from the market by the predatory pricing of Qualcomm. And then it's over to the economists to work out the counterfactuals of this world to try to calculate how much economic harm has been caused by the predatory behavior. So there we are. That's predatory pricing in competition law. But then we've got trade law. And dumping involves a firm somewhere complaining that goods are being brought onto the market at prices that are unfairly low. A definition used in trade law is that dumping involves bringing a product onto the market of another country at a price less than the normal value of that product. Normal value of the product. And then the WTO, of course, has an anti-dumping agreement. And then under the overall auspices of the WTO provisions, you then get national systems in the US or the EU, treating the EU as a nation for these purposes. You get national anti-dumping laws. It's a big difference between dumping and predatory pricing as concepts, because predatory pricing is an offence for which DOMCO can be punished. Dumping is not an offence. Dumping justifies a government in imposing anti-dumping duties. So conceptually, these are very, very different ideas. But as it were, a country can put a ring fence around itself to prevent the goods coming into the market at dumped prices. But that's not to say that dumping is in and of itself any kind of infringement. So there we are. The focus of the anti-dumping agreement is on how governments may react to dumping. It does not pass judgment on the dumping itself. If a government grants subsidies that facilitate dumping, those subsidies might be unlawful. In the EU, state aid, as defined in Articles 107 to 109 of the treaty, is illegal. But the dumping regime is different from all of that. In the EU, we have a specific regulation on dumping, and it has various conditions. I won't go into that, but there they are. Very easy to access this. If you go onto the European Commission's website and simply type into your search dumping, it all comes up in very user-friendly, very accessible ways. So, for the purpose of this talk, this is the bit I really enjoyed doing. What are the differences? They both involve complaints about low prices, but how do they differ? So, to stress, predatory pricing is committed only by dominant firms. So there's a kind of a jurisdictional threshold. Unless a firm is dominant, there's no possible intervention on the basis of below-cost prices. Dumping does not depend on dominance. Predatory pricing involves below-cost selling. Dumping is about showing that you're selling products at less than normal value. Now, of course, those prices might be below cost, but that's not the essence of it. The essence of it is selling at less than normal value. And more specifically, what are you selling at home and what are you selling at abroad? That's the bit that triggers the dumping investigation. Predatory pricing is an offence that can lead to a fine on Qualcomm of 242 million euros, and then in due course a damages claim by ICERA for the harm it suffered as a result. Dumping is not an offence. It simply gives jurisdiction in defined circumstances for a government to impose anti-dumping duties. And then what we can say is, as a general proposition, predatory pricing is a tool used by competition authorities ultimately to protect competition. Of course, consumers love having predatory prices. For those consumers, they're paying less. But the theory of harm is that that eliminates the competitor so that Domco then goes back up to charging higher prices in the long term. Long term, short term, kind of thing that the chairman referred to earlier. Whereas, I beg your pardon, doesn't matter. My last slide says that anti-dumping duties, there we go, are imposed by governments or the European Commission, as it were, to protect local firms from unfair prices of imported products. So the atmosphere of a dumping case is very different from the atmosphere of a predatory pricing case. And ultimately, cases on anti-dumping are fights between government X with government Y. Of course, it's firms in the market that are charging these prices or complaining about them, but it is in the end an intergovernmental international trade dispute, whereas cases on predatory pricing are business-to-business complaints with intervention by a competition authority, but very often predatory pricing is nothing to do with any international agenda. In fact, I would tend to suggest that most predatory pricing cases are in local markets, and they're a complaint by competitor X against competitor Y that we're in the United Kingdom and I have a bus company and you try to challenge my position in a local bus market and I charge predatory prices to get you out of the bus market. That's a real case we had about 5 years ago called Cardiff Buses. And you get these predation complaints in transport markets. They can be aviation, buses, coaches, rail services, or whatever. So predatory pricing is not, by its nature, an international government-to-government dispute. It's people on a market and one complaining that Domco is, so to speak, mashing it up. So those are my thoughts on predatory pricing and dumping, and I hope that's a helpful way of thinking about these things. But again, we've got 5 minutes, and so I can take questions. There's one over there behind you.
Sure, please. I think we have a question only because we've got only 5 minutes till
Yep.
it's Peter's turn, and then we'll have plenty of time for the session,
Yeah.
panel session, please.
Are you going to speak in English or?
Yes.
Thank you very much.
Thank you. Thank you for this opportunity. My name is Rasha, and I'm from the Information Technology Authority, particularly from the Governance and Compliance Division. It's just I would like to comment on the previous section that you talked about, the digital era, coming from the technology field. I believe it's not just the economists and lawyers need to sit on the same table only. Technologist has to do a lot with that. In order to clarify and to understand what is coming up and what is the current scenarios, especially in the digital era, because there is a huge transformation now, talking about the big data and the AI and the new trends and how the economy is reshaping itself and what kind of opportunities. Talking about traditional market and the new era, there is a lot to understand. We need to make sure that coming from a governor perspective, that the balance in the industry is well handled. We focus on creating opportunities, but we also would like to regulate the market, and we want to understand what are the conflicting interests in here that we need to work to sort out as as legal, as governors, as economists. I think it's very important to have that, a platform for a discussion to understand that. His Highness Dr. Adham had a question about the digital harm and whether we should focus on the actual or on the potential harms. I believe if we only focus on the current or actual, and I think you have answered that.
Yeah.
The potential can become actual if we don't, arrange ourselves for that. Just to give you a small example coming from the ICT industry, is that, for example, or for instance, the telecom companies, they are more into the communication side, but when you have telecom companies who have access to users or consumers' data, and now before big data and before data analytics, data was just data, and it was like, I provide you a service, and you're a consumer, you're, getting or receiving that service for whichever you pay. But nowadays, I have a big power as a telecom because we're talking about digital analytics, and I can also, enter into the IT, industry providing analytics and data.
Mm-hmm.
And if the legal tools in the country is not, paying attention to what kind of
Okay. Well, look.
power.
Let me. I absolutely get the thrust of what you're saying, and I'm just mindful of time. So, a couple of things I would say in response to that. The first is, yes, I said this is about the economic analysis of markets within a legal context. Please believe me, I didn't mean to leave technologists out of all of this. And it is actually a very serious point that you can have competition authorities with lawyers and economists, but let's face it, this industry is complicated, and there's stuff happening and technology developing and plans for the future that are almost unimaginable to ordinary human beings. And so therefore authorities have to have staff with a proper understanding of the markets that they're dealing with. I could say exactly the same about energy markets and telecommunications markets and other markets, but you have to have staff with knowledge, scientific understanding, etc. And so one of the things that we are actively looking at in the United Kingdom at the moment is whether you need to create, within the competition regime, do you have to create a specific digital markets unit staffed above all else by people with a real background of education in IT, AI, etc., etc., etc. Because you can't just expect mere mortals to apply the law to sectors that they don't understand. So I'm completely there with that. And obviously one of the bewildering things is the evolution of artificial intelligence and what problems that gives rise to for the future. You were talking about achieving a balance in what one does, whether it's the use of competition law or the setting of regulation. And of course, one of the great tensions in this area is that nobody wants to arrest the fantastic innovations that are taking place. And if you have heavy-handed regulation, or if you just break companies up simply because they're big, this may have terrible adverse consequences because it may discourage the very brilliance that has brought us to where we are today now. That's one of the reasons why I don't think it would ever be right to just say killer acquisitions are bad, because brilliant young people develop fabulous new apps in the hope that by their 23 they can sell their company to Google, take their £20 million or euros, and they're made for life, or 20 billion euros, and they're made for life. So there is a balance between, on the one hand, never discouraging or inhibiting risk, innovation, brilliance, and yet at the same time making sure that somehow the platforms don't escape and tip into monopoly. And that's the third point I was going to make to you, that there is this particular feature of digital markets, multi-sidedness, economies of scale, economies of scope, network effects, speed. There is the propensity of some markets to tip to monopoly. And if a market has tipped to monopoly, well, now we have a problem. So there is, again, a balance to be struck between the two. The Microsoft case that ended up in the General Court in Luxembourg in 2007, the states did not intervene against Microsoft in that case. The European Commission did. That created circumstances in which Google subsequently came into the market. So you could make the case that it was antitrust intervention against Microsoft that prevented tipping, that enabled somebody in due course to enter the market. That could lead to a 3-month debate about whether that was a good or a bad intervention. But what I'm saying in my presentation is there is a role for competition authorities to play. And I think maybe I'd better stop at that point, because there is a panel later on, so we can come back to these things then. Okay?